What is really important to understand in Washington State is that for a couple, the only way they can protect assets for their surviving spouse when they're gone against long-term care costs is if they do it through a will. A revocable living trust might be considered a really good idea for other reasons, but not if the couple's concern is to avoid spousal impoverishment when the first spouse dies. We'll talk about that, but a will is required. A revocable living trust doesn't work. Sometimes after I've made that statement, somebody who wants to look it up themselves, and I appreciate that, says, what's the rule? What's the citation for that? So I actually included it. It's the Washington Administrative Code 182-516-0130. So for estate planning that protects assets, you need a durable power of attorney for finances, one which includes authority to revoke a community property agreement and to enter into a separate property agreement. The power of attorney must have authority to allow gifting, and gifting that is not limited by the annual exclusion amount, which is like $18,000, or is limited to what the dispositive plan of the will looks like. It has to be very broad gifting authority. And typically, the person who is designated to act under the power of attorney for the person who signed the document is the person who would likely receive the gift of the estate during that person, the incapacitated person's lifetime who needs care. So it's really important that the documents specify, hey, it's okay if my agent under the durable power of attorney for finances is the recipient of all of my estate, even if it is against what my will says, because if they don't have that authority, they can't implement Medicaid asset preservation strategies to protect my estate. So having that authority is really important. I can tell you that if you are not having an elder law attorney prepare your estate planning documents, it is unlikely that these grants of authority will be in that document. Why is that? Because an estate planner or an elder law attorney, even who doesn't do Medicaid, isn't thinking about, I need that to do a Medicaid strategy. Why? Because they don't do Medicaid strategies. So they don't realize why it's so important to have those grants of authority specifically stated in the durable power of attorney for finances. Very important to have that document prepared by an elder law attorney who knows Medicaid. And asset protection, estate planning will not be a revocable living trust. It will be a will, and it will be a will that has a supplemental needs trust in it for the spouse or for other beneficiaries.